Well, I knew it was curious. It was some of them, like, I was. That's all.
You don't. Okay.
Yeah.
Okay.
But it are. Almost here, maybe, my mind.
I'm not a babysitter, I don't think that would be there, I just think Kirby's, so.
Because it decided that I suspect they're gonna switch it, I'm in a 4 and a 9. Yeah, you're not gonna get much. All rise. Court of Appeal in the state court is now that the Honorable Chief Craver, Chief Judge presiding. All persons having business before the court shall near citizen of the word. And God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Morning, everyone. Welcome to an oral argument session of the 6th District Court of Appeal. We have 2 cases on the docket this morning. Before I call the first case, let me dispense with a few preliminaries. Marsha Crawford has already introduced me. I'll be presiding today. To my left and to your right is the Honorable Keith White, and to my right and your left is the Honorable Mary Ardella. I'm happy to see you all this morning. This is being streamed live on YouTube, so if you haven't already silenced your cell phones, I would be truly grateful if you did. Our first case today is case number 242647, Orange County, Florida versus Stephanie Kennedy. Counsel, typical rebuttal would be 5 minutes. Do you want more or less? Great, whenever you're ready.
Good morning, Your Honors, and may it please the court. My name is Derek Angel, and I represent Orange County in this appeal from an order denying a motion for summary judgment that asserted entitlement to sovereign immunity. This court has jurisdiction under Rule 9.130, and standard review is de novo. First, I thank the court for entertaining oral argument in a non-final appeal. I know that's a rare privilege. Sovereign immunity is the rule, it is not the exception. In this case, every way you look at the theories of negligence, you ultimately are challenging discretionary decisions made by Orange County personnel who have been charged, delegated with discretion to make the decisions that they did.
I think the summary, I think the sovereign immunity substantive question is really interesting in this case. But the first thing I want to ask you about is that it appears from the order on appeal that the trial court made alternative holdings. You've got the fact that this is operational, which gets to the substance of sovereign immunity. And then you've got the notion that there might be multiple policies in effect and that there would be a genuine issue of material fact as it relates to those policies. And I think what I take that to mean from the appendix is that there is a policy that was produced in discovery by your client that suggested that an assessment for bully breeds was required. And it's undisputed that that assessment wasn't done in this case. Your client in deposition basically said that it's an outdated policy.
Correct.
And I'm wondering, because there's nothing to me on the face of that policy that suggests that it's outdated or that it's been amended or that it's no longer in effect. I'm wondering if at this stage of the proceedings, if we're not being asked to weigh in on a genuine issue of material fact.
And thank you. And I obviously appreciate that question and thought about that before I even took this appeal. Again, it's important to look at the theories of negligence alleged. That was not a theory of negligence. It was not raised in the papers by the plaintiff that that policy wasn't in effect because the only evidence in this case was from Ms. Summers, the director of Orange County Animal Services, who unequivocally stated that that policy is not in effect. So the theory is not that we didn't fail to follow our own policy. The theory has been that we should not have allowed Ms. Kitty to see this dog in the first place, or that somehow that the interaction between Ms. Kennedy and the dog should have been more closely supervised. So when we're narrowly construing summary or sovereign immunity as we must, and the cases teach us that. Now the Sanchez case is a great example of that. We do look very closely at what the plaintiffs have alleged. What is the theory of the case? It's not that we failed to follow a bully breed policy.
Counsel, do you just look at the complaint for what the theory of the case is, or should you look at more? And what did you tell the trial judge below it where they should look for the theory of the case?
Well, we do not just look at the complaint. In fact, a lot of the cases, and again, I point to the Sanchez case because the dissent in that case said, well, look at the complaint, look at all the allegations of negligence. And the majority said, no, look at how the plaintiff argued the case. That's the theory. That's not new from that case. It's long been the position of the courts of the state that we look at what are the actual charges of negligence to determine what the case is about. Now, what did I tell the trial judge? I read the transcript yesterday. I can't remember exactly, but I think what I said was.
Well, counsel, let me ask a different question based upon
Sure.
that. Is the theory of negligence being pursued in this case that of failure to warn?
Well, it's an unusual theory. I think the theory that may be part of it. I don't think it was articulated that way. I think it was the theory is which she shouldn't have seen this dog. They should have vetted the dog prior to the interaction, or they should have supervised it. I suppose you could say that they should have warned of this particular prior bite, or it wasn't a bite, it was a lunge and food aggression, but I don't know that that's what they alleged.
If it's a failure to warn allegation, why is that not operational?
Well, because the decision to make the dog available is the discretionary decision. Well, first of all, we have to understand there would be a question of fact, even if there's something wrong with this dog. That's another important part of this case. Miss Summers testified, and she is the one in charge of the entire facility, and she is the expert that the county has appointed for this role, said that we cannot make meaningful behavioral evaluations of animals when we bring them in. That's her job and her political decision to make that call.
Does that run afoul, though, of a separate policy that says that we're going to do it?
I don't think there is a policy that says they're going to do it.
Well, that gets back to my initial question. which is, aren't we weighing evidence at that particular point?
I don't think so, because the only evidence, we're at summary judgment, we're not at motion dismiss like these other cases.
Mhm.
The only evidence is that policy is no longer in effect.
Well,
Remember,
if I look at 1.510, and I think it's C1A, it talks about what can be proffered to go forward in the context of a summary judgment motion or response. And it says if you want to create or dispute an issue of genuine material fact, you can cite, quote, documents in the record. And then you look under that, and it sounds like if you're making an evidentiary challenge to say, like, for example, we shouldn't look at that because it's not evidence, or it's the only evidence on one side or the other, then you can object and say, hey, this couldn't be put into evidence if it ultimately went into a trial. But if I look at that, and I mean, the way that I was raised as a lawyer is if you're going to attach a document to a summary judgment motion, you authenticate it, you make it evidence somehow. But I don't necessarily know that the rule says that in this particular way that it's drafted. So I've got, on one hand, I've got a motion that attaches a deposition that says that this is an outdated policy. And then on the other hand, I have a response that attaches the policy that doesn't on its face show that it's outdated.
well, just because on its face doesn't show it's outdated, I mean, I don't think they go back and stamp outdated on every policy. Let's not forget in discovery, they asked for all sorts of policies and we produced as many as we could.
That's a
Does-
great question, counsel. This was produced in response to what request?
Oh, the exact language of the RFP, I'd have to go back.
Policies in effect at the time of the incident, or all policies in the last 10 years?
Frankly, I don't think the answer to that question was ever in this record.
That's fair.
Yeah, now it might be, and I don't know if they filed the RFP and we could go back and look at it. I'm certainly not prepared to answer that
That's
question.
fair.
I sit here. But either way, just because something produced in discovery, once the only evidence is that it's outdated, I think that is the only summary judgment record.
But counsel, wasn't the entire policy, including the policy that the chief is speaking about, multiple sections, is exhibit 2 to your client's motion for summary judgment? Your client injected it into the matters before the court for summary judgment, didn't it?
I wouldn't be surprised if I did. But again, that doesn't change what the evidence is. I mean, the evidence is that it's outdated. It's the only evidence. No reasonable fact finder, which is the task force, could say that that was in effect when the.
And that's a,
only evidence is
that's a different one.
out.
Let me go back to what Judge Nardello was asking, because I think it's a really interesting question as it relates to what frames how we view the issue in front of us on decisional versus operational. So I think what I understood you to say is that we're not just going to look at the operative pleadings, and you cite the third DCA case to basically suggest that we're going to look at the summary judgment record in this particular instance. The response, as I read it, says defendant Orange County, Florida breached that duty when they failed to control and handle the pit bull. Ms. Kennedy was not warned, advised, or made aware of the dangerous and vicious nature of the pit bull involved in this subject incident. And I'm struggling with how I don't read that as a failure to warn.
Well, again, the problem is that there's an inherent fact that the pit bull was vicious, and also this is the important part, that there's something wrong with adopting out a vicious pit bull. That is the critical discretionary point here. And look at the city of Austin case that I cited from earlier this year. That case is interesting. They apply a very different sovereign immunity scheme than we do, but it just underscores how political these decisions are with stray animals. In the city of Austin, the dog in that case had actually bitten a 7-year-old. It was then adopted out and bit another child, and they found sovereign immunity because the city of Austin had a no-kill policy. And so some people would say that a dog that has vicious propensities should just be straight up euthanized, or we should assess their character or whatever you might divine with an animal. But in Orange County, the dogs come in, they made a conscious decision not to do a behavioral assessment on intake. That's clearly in the record. And then they monitor the behavior, but they make the decision as a policy matter to continue to make these animals available.
That's fair, counsel, but what about the fact that a failure to warn count does seem collateral to that? And I think you have a stream answer, and I'm interested to hear it about where we should freeze the question of negligence, but a failure to warn claim seems to say, yes, you made all these policy decisions, but you would have still owed me the duty to tell me so I could make a decision if I wanted to see that dog.
But to tell you what, that's the problem.
That this
Warn
dog
of
was
what?
food aggressive.
But what does that even mean? I mean, that's my point. We're dealing with animals.
Wouldn't it at a minimum mean disclose information you actually know?
Well, so now we're at, I don't think so, and here's why. Because now what we're saying is we want, we're changing the policy here in a subliminal sort of way by saying that we now, before we allow anybody to look at any given dog, disclose the history of everything we know about the dog. They didn't do that. In fact, what's interesting about their policy, which people could disagree with, and that's the important part. These are judgmental.
Let me ask you about the policy where it says interactions should be monitored and quote, guidance given to customers on the importance of sanitations of heads, hands, et cetera. What does that mean? What's guidance? That's the policy.
It
That's
is.
the articulated policy that you are asking properly, I believe, for us not to interfere with. Couldn't a failure to warn be
Well, I don't think the
construed as part of that policy?
Again, warn of what? I have a problem with. What we're warning of is inserting ourselves to say we need to tell them everything about the dog, which they decided not to. Other people would say we need to do a behavioral assessment on the front end, which they decided not to. And in this case, what else could have been done with respect to the actual interaction with her? That policy was followed to a T. The dog was walked out, taken out of the cage, handed off.
I feel like that's not necessarily, and I might be misunderstanding the question, but I don't necessarily feel like that's the answer to the question that was asked, in the sense that the policy specifically speaks to a handler who is there, who's present. Obviously, somebody's got to unlatch the cage and walk the person out to the run. So somebody's actually there, and they're instructed under the policy to give guidance. There's an et cetera there that causes me some questions too, but what's the point of telling somebody giving guidance on hand sanitation?
I think that's just, be careful, the dog might be dirty, I don't know.
Yeah.
It's on the animal.
Maybe you might get the dog sick from something on your hands, or the dog might get you sick from something if you don't walk, but I guess I'm just wondering what the point of giving guidance on washing hands is, if, for example, and I'll stray outside of the fact pattern of this particular case, assume that this particular dog had attacked, maybe not bitten, but attacked the last 10 potential rescuers when they did a certain thing. I'm having a lot of trouble. Potential rescue do that one thing.
See, that is exactly what this case right there is. How are we going to animals, right? Just because the animal has a bite history or a food aggression history. Different people have different interpretations of that history, dealing with and it's that we can't do, right? This is an animal. Would think the director of this city of other people would say we need to disclose all this to potential adopter with a house with a 3-year-old. Other people rehabilitation or whatever else, it's personality. And those are the political decisions, I think, that are implicated by this entire charge of negligence. Every way you cut it, it comes back to those questions. How do we deal with the problem of stray animals? And different people have.
That was a decision not to have a warning policy.
I don't know if there was a conscious decision not to have a warning policy. That's kind of a conscious, like a negative, proof of negative. But I do think it's clear that they made a conscious decision not to do a behavioral assessment before making it available, and that they only make behavioral assessments after something happens. That was also clear in the record. In this case, for example, Boyardee, the animal, after this incident was taken back to the behavioral assessor, who then they quarantined the dog. That's where they decide whether they're going to put it back out to the general population, or in this case, euthanize.
If the bully breed assessment policy is in effect, or if there's a question as to that, then summary judgment was properly denied.
Honestly, I didn't study that policy coming in today, but because I don't think it's brought up by their arguments in this case, but assuming that it is, I do probably think that's correct. However, I think that's going to the scope of review here, and I don't think there's anything in Rule 9.130 that says if we have jurisdiction to review an order granting summary or that asserts the entitlement of sovereign immunity, that we can't look at the whole order. I don't think it was correct for the judge to say that policy is in effect. The plaintiff has never argued that policy is in effect. That's important. That's critical. I never saw it in their response to the summary judgment. It was not brought up at the hearing. And if I don't think it was anyway, and it certainly wasn't in their answer brief. So
But the judge did seem to put it in her order, correct?
she did put it in her order.
Did you have a duty to challenge that in your initial brief?
I did challenge my initial brief. I certainly put in a footnote in. the
Right, there's a
statement.
footnote.
Yeah,
Is that enough?
I think so. Because
It's two sentences on page 7 that begin with as an aside. Like, I didn't see any independent legal argument on it. I didn't see any separate legal analysis on it. And then in the reply, there's the statement that, oh, because they didn't mention it in their answer, this thing is conceded. I think you'd agree with me that that probably doesn't appropriately state who has the burden.
Well, I
in
think
this particular case.
burdens are very interesting in this proceeding, right? Because obviously it's my burden to show error on appeal, but it's also their burden to show that sovereign immunity doesn't apply. There's some very interesting shifting burdens in a sovereign immunity appeal at this phase, at a summary judgment phase. I know there's a lot of federal case law that talks about this because they have a lot more history to these sorts of questions. But I think that when they do not make an argument that that policy applies, which they didn't, either in their answer brief nor in response to summary judgment, I don't think I have to disprove that because, again, it's their burden to show sovereign immunity doesn't apply on the front end. And they didn't bring that up. The court did. I said, I think the court was wrong here. They didn't back up the court. Let's put it that way. I think that is would not be appropriate vehicle for affirmance respectfully. So I don't think that's a legitimate issue in this case.
You got 4 minutes left. Do you want
I
to save the rest of it?
I think I'll be, unless there's any other questions at this time, I think I will save it. Thank you very much for the discussion.
Thank you.
Good morning. May it please the court. My name is Max Carrick, and along with Ms. Paige Staudenmeyer, we have the pleasure of representing Stephanie Kennedy in this appeal. Before I dive into it, I want to thank your honors for the opportunity to be here. It's rare to have first opportunities at this point in my career, so it's both an honor and a pleasure to appear before the three of you. As the court has gone into thus far, there's two real issues: whether or not this was an operational issue or involved that high level policy planning allocation type analysis, and then part two is the policies and whether or not there was a conflict in those policies. I want to start with the policy because that's, I think, the more simple approach. And Judge Nardello, you had asked initially, what was that produced in response to? And that policy was produced in response to a.
Are you about to stray outside the
Yeah,
appendix?
I probably
I don't
invited,
think, I don't,
but it was in the record.
Is it in the record?
yeah, it should be, your own. Yes.
Do you know where? And if there is a place that we're missing, can you just get us a page number before you say what you're about to say? Do you need a moment to confer?
Just a moment.
Yeah.
So Ms. Staudenmeyer's going to try and do that, and
Great.
without going outside of what we've talked about.
Counsel, not to take you out of
Sure.
your framework that you
Absolutely.
have, but can you answer the question that we were just asking opposing counsel, which is, he makes the point that your side has never made an argument that the bully breed assessment policy applied at the time of this incident. Is that true?
No, absolutely not. It was submitted in support. It was their side filed it as part of the responsive documents and made it a part of the court file. And then the court made a decision upon that.
Where did you argue that in your response, though?
To the initial brief.
No, in your response to the motion for summary judgment.
We did not. That was a determination that was made by the court based on the facts that were put before the court, which I think.
Right, that's my question. Below, where did you argue to the trial judge that this bully breed policy was enforced? So that when she wrote an order which says we have a issue of fact still to decide, which is what policies are enforced at the time of this incident. Was
It-
there, go ahead.
Sorry, Ron, I did not mean to cut you off. It was in our response to the motion for summary judgment, which I think I have handy.
We have it, counsel.
I'm sorry.
We have it.
Yeah, we have it.
Oh, okay, yes. So it was in the response to the motion for summary judgment. We specifically cited to that and then highlighted the dichotomy between that And what the corporate representative for the county talked about, that director, and said, oh, wait, no, that's outdated. Which raises it's evaluating the evidence. It's honestly weighing the credibility, because the jury can either decide to accept or reject her testimony. And if they reject her testimony and find, based on the full scope of the evidence, that that policy was in fact in effect, based on the county producing that to us in response to discovery,
Okay.
they could expressly reject that theory and very reasonably rely upon that in finding that the county.
Counsel, if we take out the bully breeds issue,
Yes, sir.
let's say we disagree with you on that, and I'm looking at a complaint which says they failed to control the pit bull. I don't understand that allegation, considering that your client had control of the pit bull. She was given the leash pursuant to a policy to take the dog around to a specific place and see if this is a dog she wanted to adopt, right? So how did they fail to control the pit bull?
So when we talk about control, it's not the exclusive actual physical control. There's control over the animal. The general possession is in the county possesses the animal. And in doing so, they have that duty to exercise control over the dog in a reasonable manner. And not just turn it loose to somebody, hand it over.
But the policy is to turn it over.
Are we talking about
The policy is to let potential adoptees interact with the animal they would like to adopt.
well, and that's where I disagree with the county's representation that the policy says that it should be exclusively handed over to the person adopting and walk away. That's not what. the
But isn't that what
policy
your
says.
opponent's gonna say? You just said you disagreed with the policy.
No, I agree with their representation of the policy. I think the strict reading of the policy does not say that the dog should be handed over and that the person for the county should absolve themselves. It actually says quite the opposite. And Judge White brought it up and Judge Traver touched on it as well and said that based on their policy, if we're following to the letter, as counsel suggests, that these interactions should be monitored and guidance given. And I know that there was some attention drawn to that, et cetera. And I think that et cetera is important when taken in conjunction with the should be monitored and guidance given, especially when we add in the knowledge that the county possessed that 9 days prior to this incident, that this particular dog had exhibited aggressive behavior.
Can I go back to Judge Nardella's question, though? I don't necessarily know if we're just looking at the allegation in your complaint, which is a very simple failure to control allegation, how we can read a failure to warn.
Well, and I agree with you, Your Honor. If you read it exclusively based on the complaint and not taking the entirety of the sum of evidence and the argument as counsel highlighted that we're supposed to do on appeal, if you read through the argument, we detail how they failed to.
Where does that come from, though? You know, typically when we go to trial, what you can argue in trial is cabined by your pleadings unless it's done by consent. Is that a fair statement?
Yes, Your Honor.
So are you suggesting that you could stray outside the pleadings in the context of the summary judgment record by, and I think it's pretty clear that you argued failure to warn in your response to the summary judgment motion. Are you suggesting that you can stray outside the bounds of the pleadings by consent in the summary judgment framework? In other words, if he's wrong, and we only look to the complaint, can you win this appeal?
Absolutely, Your Honor. It goes to that.
Let me finish my question,
Okay.
because I think you're gonna go to alternate grounds like you did with Judge Nardella,
Yes.
which is failure to control. But if we look at this solely under a failure to warn umbrella, and you don't mention that in your pleadings, and he's wrong about us being able to look at the response to the summary judgment motion, where does that leave you?
So our complaint sets forth that there was a failure to control and then allowing the interaction. And I agree. I think what the court is saying is that allowing to interact is kind of vague and not very concrete, and expressing that failure to warn.
Well, I think what you said is that it doesn't. And I think I agree with you.
Yeah.
That a failure to control is not a failure to warn. And then my question just becomes, well, if this is a failure to warn case, and let's say for the sake of my question, that the only way that you win is on a failure to warn analysis, where does that leave?
I would agree with Your Honor that based on the strict reading of the pleadings, that there is not a failure to warn count pled. Now, again, I know you want staying away from the counter argument, that folds into the control. How do you control the animal in light of the knowledge that you have? And it's not necessarily a failure to warn, but it's a failure to act reasonably and exert specific controls based on that knowledge that you have, that you possess. In that there's additional precautions you can take in exercising this animal. This Boyardee could have been placed in a muzzle, the opportunity presented to Ms. Kennedy, okay, you know, you've had some time with us, do you want to take the muzzle off? There are certain things that the county could have, and our position is arguably should have done to control the potential aggressive nature of this dog, which is our position would be subsumed within that failure to control count that we did allege in the complaint.
My first question to your colleague had to do with the alternative ground for it. Is there anywhere in the pleadings that suggests that there was a failure to assess, which would be the problem under the bully breed policy?
A failure to assess, no, that was not a pleading.
Is
Again,
there a legal argument in the response to the summary judgment motion that there was a failure to assess?
it's not and I promise I'm going to answer your Honor's question. It's the frame of our question is we don't take issue with the fact that there is a policy. We take issue with how the policy was carried out in light of the knowledge that the county possessed, which again takes us out of that legislative high-level allocation analysis. We're not taking issue with Section 6 requiring interactions between a potential person adopting a dog and a dog. It's how it was executed by the county in light of that knowledge that they possessed of that prior aggressive incident. So to answer your question, it's not a direct one-to-one correlation between the failure to assess. It's how did that failure to assess play in? And arguably, the failure to assess doesn't necessarily matter because we have an aggressive incident. It's how did the county react to that aggressive incident and what did they do based upon that knowledge? And the answer based on the record is absolutely nothing. They did nothing. They took no measures to exhibit additional control over this dog, which had demonstrated aggressive tendencies. And so the question based on that failure to control is, was that reasonable? Was it reasonable for the county to do that in the manner they did in light of the knowledge that they possessed? It's just a traditional negligence analysis. Would a reasonable person, albeit company or association or governmental entity, done this? Or was it reasonable for them to do so in light of the knowledge that they possessed?
Go ahead. Yeah, please.
Counsel, so looking at your argument and your opposing counsel's argument, if I could kind of distill it down, you're saying no sovereign immunity because it's operational. County says no, discretionary sovereign. Looking at the cases, seems to me courts make a decision. In this particular case, what's the framework? How do we make this decision? Because on the one hand, you could say, well, depending on the argument, you could always frame something to be discretionary. But on the flip side, with a different argument, you could always frame something to be operational. And that's a concern. Would you agree?
Absolutely.
Because we're dealing with sovereign immunity, which
Absolutely.
the policy of that separation of powers. So if we're struggling with that, how to draw this line? At what point is it appropriate? Meaning we don't see that this is a separation of powers infringement on the other branches. How are we what's the analytical framework?
So there's the official analytical framework, which is the 4-part test. And then there's what I call the allocation versus execution analysis. They're largely the same. Mine is just way more distilled. But the formal framework is the commercial carrier versus Indian River analysis, where you've got those four parts that you go through and both the defense and, or I'm sorry, the county and in our response, we went through and assessed each one of those. And, but what that essentially boils down to is, did it fall under the governmental entity allocating funds or people, or did it involve a specific expertise? Did the decision go to that, or was it in carrying out a policy? And in both, actually, the initial brief and our reply, there was discussion of the Sanchez case down in Miami, which was where the two kids were shot at the park, and they brought suit essentially for negligent security. And what the court found in that particular case, and I think that was the third district, found that that was an allocation of resources analysis, that county made the decision not to allocate off-duty officers to that particular park on that particular night. And because it came into the allocation and how do we divide up our assets, that was that high-level decision-making discretionary, and that was, they were immune from tortious claims. Then we've got the alternative, or I'm sorry, the city of Daytona Beach case also follows that same kind of analysis, but there they dug a little bit deeper and talked about if it's the firefighters in putting out a fire, that say they shoot a water cannon and it blows through a window, and in blowing through a window destroys something behind it, that falls within their expertise, that they are fighting fires and that's how that's supposed to go.
Can I ask a higher level question?
Sure.
You know, the four-part test talks about acts, omissions, or decisions. What's the act, omission, or decision that you're saying is at issue here?
Is not taking additional steps to protect not just Miss Kennedy, but whoever is interacting with this dog.
So it's an omission.
Yes.
Okay.
Yes, Your Honor. It's failing to take that next step to protect anyone interacting with this dog, even someone who works at the county, and make them aware of this prior aggressive incident.
I feel like your colleague would say, and you very much seem to be missing each other in the briefs. I feel like your colleague might say, and I'll ask him about it, is that it's an act that, or a decision, in the sense that it's the act or decision on the part of the county to decide that in whatever circumstances, it's important for potential rescuers to have one-on-one interactions with the dogs that they might potentially rescue. So I think you guys might be talking past each other a bit, which is making it confusing for us.
And I do agree. We don't take issue with the policy of them interacting. It's how it's carried out. And that takes it from the policy level to the operational. What are the steps that are taken, and are those steps reasonable? And that's where we meet, was this a operational failure in how this Section 6 policy mandating the interactions was carried out? The county says they did it by the letter. Our position is they didn't, and they violated their own policy. And I know that setting or internal policies doesn't necessarily set the standard for negligence. I think that's the Walmart case out of the fifth, but it certainly goes to whether or not there was negligence. And just reading the county's own policies, they didn't follow their own policy. There was no monitoring and guidance based on their testimony. They just handed this dog over to Miss Kennedy and said, here you go.
I want to switch you back to the alternative holding very quickly. My last question on it, I promise. Your colleague said that you've got on one hand unrebutted testimony that says that the policy is not in effect anymore, and on the other hand, you just have the policy. Could you address his no reasonable jury argument under the new 1.510 standard?
And
How does that create an issue of material fact?
I touched on that before. The policy was produced by the county.
Oh, now's a good time to, please.
And so, Your Honor, the record was filed in the appendix, and so it was our 220. Sorry, I have it.
Just the record itself, but not, it doesn't look to me, for example, that the underlying request for production was filed or answer to request for production. Response, I should say, to request for production. Is that fair? Because the freestanding document is certainly there, but I think the question was, why was that produced in response to what question? And I just don't see in our record anywhere where we have that. That was my question.
It was the 22423 request to produce, which I'm looking at the appendix, which was filed. So based on what I'm reviewing, it appears it was filed with the court, Your Honor.
Yeah, I'm just looking for a record site.
Right, the trial court versus. Not record.
That
We
It's
can
not-
cite it, counsel.
Okay. All right, thanks. Do you guys have any other questions? If you'd just like to conclude, thank you.
absolutely. So for those reasons, we would ask that you affirm the denial of the motion for summary judgment. Again, thank you for the opportunity to appear in front of you all. It has been an absolute pleasure and pleasure. Thank you.
Thank you. I want to start, if I may, to answer Judge White's question about the framework and the higher level questions here. If you look at commercial carrier and read that entire case, that was decided not long after we enacted 768.28. And it was looking what all the other states had done following the Federal Tort Claims Act, which was 1946, and other states falling in line. And that's where we first get the planning versus operational. That came from the Supreme Court of California, actually. And even the Supreme Court, our Supreme Court said, those are just kind of guideposts. In every case, we're going to be looking at this case by case. They use that term. They also look at the Supreme Court of Washington, which is where those 4 prongs come from. And they say, well, even these aren't determinative. So if all 4 point in favor of the government, we're probably immune. But if a couple point the other way, we have to look farther. So the way I look at all this, and this is, I'm going to read from, they quoted this law review article from the University of Washington, 1956, but I think this answers a big part of the question here. And again, this is the context of we're challenging a discretionary decision, not a lack of maintenance or those sorts of claims. As we're in a subset of challenging a conscious decision by the executive. It's a lengthy quote, but here it is. It's one sentence. Liability cannot be imposed when condemnation of the acts or omissions relied upon necessarily brings into question the propriety of governmental objectives or programs. Here we go. Or the decision of one who, with the authority to do so, determined that the acts or omissions involved should occur or that the risk which eventuated should be encountered for the advancement of governmental objectives. Been very wordy, but the point is, as long as the person has been properly delegated discretionary authority under the executive branch tree that ultimately points in our case all the way straight to the mayor, then the courts are sitting as a supervisor of that if they are challenging that question. That's why policy is so important, because when an executive actor goes outside the scope of the policy, for example, in that city of Newport Richey case where the cop violated all these high-speed chase protocols, we can no longer say that negligent act was properly delegated to him, right? If he's not supposed to be chasing somebody at 93 miles an hour in a 40, unless there's a forcible felony, which there wasn't in that case, then we can't say that a discretionary person within the executive branch, in that case, the police department, authorized that act. They are no longer acting within that tree of delegated authority, and therefore we can charge them with normal negligence. The respondeat superior would apply. In our case, however, every single act that I've heard that's been challenged ultimately is the proper execution of discretionary decisions that reasonable people may disagree with. Again, reasonable people can disagree that a dog that shows any sort of aggression should be adopted out. There's certainly people out there that believe that. But in our case, no one went outside of policy. Everyone was within their delegated tree. And I think that's the important test here from a high level analysis. And a great example of that is the city of Daytona Beach case with the firefighters. Those were end-line firefighters that the Supreme Court decided were acting within their discretion by deciding to fight a fire a particular way. That doesn't mean that they are blanket immune, right? If they drop the hose and it sprays and hits something else, that's a mistake. A mistake would be operational negligence, right? And I think that's one way to look at these cases. When you're challenging a discretionary executive act, was there a mistake involved? Was there an error? That's an operational failure, right? We look at the Guglielmi case where the police dog was on patrol. Nobody intended for that dog to bite anybody. That was a mistake. You let the guy get in too close and failed to control the dog, and we have a bite, right? That wasn't intended by anybody. But what was intended was for him to be on patrol in the first place, and that was immune. So in this case, we still need to ask ourselves, what is the challenge decision that was made that is negligent? And all I've heard is they should have controlled it better. And I think Your Honor brought out the fact that the pleadings are very specific about that, and they are. And I looked at the response while my colleague was up here talking. I didn't see anything about the bully breed policy in the response. And I didn't see anything about duty to warn, but I don't know what we're warning of.
Yeah. So you're over time, but.
Oh, I'm so sorry.
But just for
Somehow
the,
didn't
just for
notice that.
the sake of it, I look at the response, if we're talking about the response. And it specifically says, and I read it, not warned, advised, or made aware of the dangerous or vicious nature of the dog. I don't know how that's not a failure to warn claim.
Well, I think I've made my point of
Yeah, I
what are
think-
we warning of, and I am out of time, and I, unless there's any final questions, certainly thank the court for its consideration of the case.
Okay, thank you. Thank you
very
both.
Thank you both.
You guys are okay.
All right, the second case on today's docket is Bank United NA versus K Barrington Dunn. It's case number 24-1880. Counsel, how much time would you like for rebuttal?
5 minutes, please.
Whenever you're ready, sir.
Thank you. Good morning, Your Honors. Eric Levine here on behalf of the appellant Bank United. May it please the court. The order of involuntary dismissal entered in this case should be reversed. It goes without saying that involuntary dismissal is error when the plaintiff proves a prima facie case. In foreclosures, to establish a prima facie case, a foreclosure plaintiff must prove 4 elements: an agreement between the parties, a default by the defendant, acceleration of the debt to maturity, and the amount due. The answer brief does not dispute the Bank United established all 4 elements.
Counsel, can I ask you a really basic question? We list the 4 elements out. Is validity of the mortgage basically encompassed in those 4? Do you have to prove the mortgage is valid?
No. I'll explain why. So the fact that mortgage is in evidence, which it is, Florida law provides under Florida statute 95.281, that a mortgage is valid for 5 years past maturity. This loan matured in 2023, so 5 years plus that is 2028, if I did my math right. So Florida law already provides a presumption. But the Bruno case, which we cite, and I believe the Florida Supreme Court in Biggs, which the appellee relies on, says, if you're going to take the position that a mortgage is valid on its face, presumably still within the statute of repose, is invalid, you could do that as a valid affirmative defense. But it's an affirmative defense. You have the burden to prove it. And so here, because we established.
Did your client have a duty to avoid it with a reply?
No.
Why not?
So replies, first, I'll say that whether or not we pled it as a reply only becomes relevant and material once they've established the affirmative defense. And since we never got there, because they never established the affirmative defense because this was involuntary dismissal, what we pled and reply is irrelevant. Second, to go right to your question, a reply does 2 things. Well, if you don't reply, it's deemed denied. It's unlike a answer to a complaint. If you don't deny it, it's admitted. If you don't deny it, it's denied. So right away, the affirmative defense of, hey, this has been released is already denied just by not replying. Second,
Was that denied as to a factual matter as to whether the release was actually recorded?
well, the release was recorded. It was not in evidence, but the release was recorded. We admit that. I'll give in candor to the court. The release was recorded, but what exhibit is it? It's not any exhibit.
Okay, so what was denied then?
She pled in her answer that there had been a release. And so by denying, by not applying to it, it's deemed denied. The validity of the release is denied, or the fact that it's basically that this mortgage isn't really released is being denied. Second, a reply, the purpose of a reply is to put in new facts that would operate as a denial, show that the affirmative defense should be avoided. However, our complaint already pleads all the operative facts the court needs. We plead the execution of the loan documents. We plead there's still an amount due, $11,000 in principal, and we plead paragraph 4 of the complaint that the mortgage is valid and the lien on the property. Now,
Now
I
you
know
have to plead mistake in
I-
avoidance of the reply. of
No.
release.
you do not have to. Now, to be
In this case, since that's what I understood your argument to be at trial.
No, you don't need to plead it. You do
Why
not. Because under Supreme Court precedent, if the evidence shows that the release was a mistake, then the evidence shows that, and the court and sitting in equity can grant foreclosure. I
Counsel, the Supreme Court precedent you're talking about, what year was it published?
believe Bruno was the 1930s. Bruno, I'm sorry, Bruno was much before this year.
Is it
Big-
Azor you're talking about, 1940?
I believe that was the year I can try, but Biggs, 1938. But if you look at Bruno, which is
But none of
obviously
those cases, that predates the Florida Rules of Civil Procedure, does it?
the modern rules, yes,
Okay.
but I believe,
So let's look at 1.100 sub A, where it says, if an answer contains an affirmative defense,
Mhm.
and my understanding reading the record, it was agreed that the appellee pled the affirmative defense of release, correct?
I believe they did, yes.
The opposing party seeks to avoid it, the opposing party must file a reply containing the avoidance.
It
Right.
does say that, yes.
So if you didn't file a reply, and if we disagree with you and we find that mistake is an avoidance, and I guess a two-part question, do you believe that mistake must be affirmatively pled under 1.120B, which says in all averments of mistake, mistake shall be stated with such particularity as the circumstances may permit?
Okay. So I'll start with the easy answer, at least easy to me, is it doesn't matter based on the procedural posture of the case. Because whether or not we pled a proper avoidance, a reply as an avoidance would only come up once the defendant proves their affirmative defense of the release. And since we never got there, since we're here on involuntary dismissal, whether we replied or not is irrelevant because there's no affirmative defense proven to be avoided. That might come up once the affirmative defense is proven. Second, it came up at trial. The evidence at trial admitted shows that this was a this was a mistake. So I would also submit that the evidence for the court could consider this tried by consent. Because obviously the evidence before the court, and I refer the court to Exhibit 4, the servicing notes, the collection notes, which specifically say in them, they're in evidence. I know counsel, I think, trying to raise a hearsay objection for the first time on appeal or unpreserved one, but they're in evidence and they say it was wrong, it was mistaken, and they said in the service.
Where does it say, where does it use the term wrong or mistaken?
I'm using shorthand, but I believe I'll pull up the, let me get it up right now. Oh, here, Exhibit 4. So on page 802 of the record, this is the service notes, Exhibit 4. It says the payoff was done in error back in 2018, and they continued to make payments for over a year after payment reversal. It's very small fonts. Payoff was done in error. So you have it here saying it was done in error several times. And then on page 807,
I'm sorry, were those notes contemporaneous to the time of the release, or were those after the fact notes by your client in, say, 2021?
well, these particular notes are from 2021, but whether or not they're contemporaneous or not, they're actually looking at the payment history and they could see there's still an amount due and there's still payments being made. It seems very odd that if Ms. Barrington paid off her mortgage in 2018, she'd still be making payments into 2020, which is what the record shows she did. And then on page 807 of the record, it says specifically affidavit of recordation of error in release of mortgage recorded May 25th, 2021, instrument number 2021-03-14390. So we have in the record, not only the note saying it was wrong, we have in the record evidence that they recorded in the official records that it was wrong. And on,
I'm sorry, who's they?
the servicer at the time was NationStar at the time, who would have done this. And the lender, the servicer for the lender.
I'm sorry, and the document and evidence specifically states that the affidavit of error, we'll call it, was recorded by NationStar?
It doesn't say here who, it doesn't say here specifically who recorded it, but it says it was recorded. And on a motion for involuntary dismissal, where all facts are deemed in favor of the plaintiff because there's no weighing of evidence and it's on de novo review, this court has to look at the record and say, it is true that it was an error. It is true that it was an affidavit of error was recorded. Giving all that the presumption of truth, which we do here, involuntary dismissal was wrong. Because we established a prima facie case and the evidence showed that yes, a release was recorded, not in evidence, but spoken about. And the evidence showed it was wrong and payments were made years after. And so on this record, involuntary dismissal was error. There's the burden was on the defense to prove the release. And so we would ask, so this court should follow the fourth DCA's lead in the Bruno case, which is 2016. And that case is as close as you're going to get in the legal field to being exactly the same facts as this case, but it's as close as you're going to get, where, and I can read some quotes. The trial court granted the defendant's motion for involuntary dismissal on the defendant's affirmative defense that the mortgage had been satisfied based on a recorded affidavit introduced during the plaintiff's case. And the fourth DCA reversed and said, on a motion for involuntary dismissal, the trial court may not weigh the evidence, but must view it in the light most favorable to the non-moving party. Here, the plaintiff presented a prima facie case to foreclose the mortgage. The fourth district then remanded for, quote, trial of the affirmative defense that the mortgage had been satisfied and whether the document purporting to satisfy the mortgage was in error. So here, we have all four elements to foreclose a mortgage proven, or at least prima facie proven to me. And we have evidence that while an assignment, a satisfaction was recorded, we have evidence that must be taken as true that it was in error and it was and a affidavit of error was recorded. Now,
In your preparation for this oral argument, did you come across a 2010 case from the second DCA called All Real Estate Title Services versus VUU?
it's not sounding familiar off the top of my head.
Let me just ask you generally about it, and I'll read something that was, and it's citing a Florida Supreme Court case from 1955 for the proposition that, quote, court may apply equitable principles to reverse the cancellation of a mortgage satisfaction when that satisfaction is a result of mistake or inadvertence. How do you read equitable principles in the context of reversing a cancellation?
So equitable principles, so we all know mortgage foreclosure is an equitable proceeding. Equitable principles means that if the debt isn't paid, which in this case, we have to take as true the debt's not fully paid, and it's shown that a satisfaction or release, whatever you want to call it, is recorded, and it's shown that it's an error, which has all been done here, in this case, as a matter of equity, the court can basically still grant foreclosure, notwithstanding the release.
Could
And
you
that-
read equitable principles as necessitating a claim for rescission of that satisfaction?
No. First of all, equity, what's the Supreme Court, US Supreme Court, I don't remember the site, but equity abhors rigidity. Equity depends on flexibility. That's a US Supreme Court case. I don't have the site for me, but I read it recently. So equity never follows rigid rules because that's the opposite of what equity is. And I'll cite the court to Cooper versus Walkowitz, which we cited in our brief. So Cooper versus Walkowitz, that exact issue came up. I can't remember who, Mr. Walkowitz gave Mr. Cooper a cashier's check for a full payoff of the mortgage. And in return, he gave him a satisfaction. That check was dishonored by the bank. It was returned uncollectible. And Mr. Cooper was in the position where, hey, I'm not paid. And the mortgage is still, I gave a satisfaction. The third DCA looked at that because Mr. Walkowitz said, well, you should have pled a claim. You should have pled a separate count to set aside the satisfaction. And you didn't, so you lose. The third DCA said no, expressly on that exact point, said no, you don't need to plead a separate claim. Once you establish with evidence that the debt is unpaid, and the release was an error, or in this case, in that case, it was based on the presumption the check would be honored, it wasn't. The court in equity can grant foreclosure, notwithstanding the failure to plead a separate count.
But the presumption is what that case is about. It's a presumption of payment versus a presumption of the release being valid. Do you not see that as being different in kind?
No. So in that case, the release was definitely valid. In that case, the release wasn't even a mistake. Mr. Cooper knew what he was doing.
I know, but what it stands for.
Well, that case stood for the fact that was Mr. Cooper required to plead as a separate cause of action, some sort of action to set aside the erroneous release, which is what they've said here. We should have had a count two. Cooper versus Walcott said no. And I don't know of any case that says you actually have to plead it separately, which would run afoul of equitable principles.
Some
So-
states have statutes which deal with what you do when you
Sorry?
file mistakenly a release.
I'm sorry, I didn't hear the
Or-
question.
There are some states which have statutes which deal with the very instance that we're here on, which is what does a bank do? What does a lender do when they file a mistaken release? Can they unilaterally correct that mistake by filing something in the record?
So-
There is no statute in the state of Florida, is that correct?
I'm not aware of any, and certainly none's been cited on that point. So Florida is a notice state.
Right,
Just regular, going back to regular with 95.695.11, we're a notice state. That's why if you record an erroneous satisfaction, you better record something that says it was wrong. Because that way, everyone who comes after you has noticed that there's a problem, which is exactly what they did in the record, although a copy isn't here, that's exactly what they did. Then, when you come to court to foreclose your mortgage, do you have to plead a separate count to undo the erroneous satisfaction? Cooper versus Walkowitz says, no, you don't need to do that.
but Cooper's not binding on this court.
Cooper's not binding on
So
this
tell me,
court.
tell us why Cooper's right.
Cooper's correct because, as I said, equity abhors rigidity. Equity requires flexibility. The rules of civil procedure, what is it, the first one, 1.010, these rules are designed to afford the, speedy, effective justice, pursuit of justice. The rules are designed to avoid prolixity, I think is the word they use. We don't want complaints being longer than they need to be, right? As long as you plead the fact showing what you're asking for, you state a prima facie case, which we did. Now, I know they pled an avoidance, they pled an affirmative defense, and maybe they could prove their affirmative defense, but we never got there. Now, I want to spend the last 5-6 seconds before I move into my rebuttal time to talk about remand, because I did say in the brief, we were asking for remand for entry of final judgment of foreclosure. On further review of this record, I don't believe that's probably appropriate to do that. I think that this court should follow Bruno and say that prima facie case was established and remand for trial of their affirmative defense, at which point this could be flushed out more on the merits.
Counsel, before you sit down, I want you to come back on the rest of your time and answer this question. On the record site, page 661, when we go over the affirmative defense that was pled here, counsel says their first affirmative defense is the mortgage is released. They then go back and they get time to research. And counsel says you have to literally reestablish or reform the mortgage. That's what he tells the trial judge. He says, but the bottom line is there's nothing in this case that the witness even admitted. There is not a judicial order breathing life back into this mortgage. That's their argument. Counsel says, Attorney Bassett, do you want to respond? That's counsel for the bank. Counsel for the bank says, I don't disagree with counsel.
Okay.
What do we do with that?
Sure.
Is that out? Yeah, and I'll give you time. Is that out of context? Is that a concession? Did we invite error? Those are the things I'm curious about your response to.
All right, I'll respond shortly. Thank you.
Please, the court. My name is Attorney Anthony Lejean. I have the pleasure of representing Ms. Barrington, and I also have the pleasure of actually being the trial attorney that was present during this trial. The Cooper case is one of the major cases that is at issue here. And the Cooper case made it clear that a release of mortgage creates a rebuttable presumption of payment of the underlying debt. And I want to correct my opponent on one thing. He said it was our burden, and it's actually their burden to overcome that presumption. And I also want to correct one other thing. There's a lot of focus on whether this is an affirmative defense, but touching on what Judge Nadella was pointing out is that whether there was a release of mortgage is it's inherent within the 4 elements that they have to prove. And in this particular case, if you look at
What case holds that?
What's that? There is no case, that actually says that per se that I'm aware of. But if you look at their pleading and the complaint, for instance, paragraph 4 alleges that this is a mortgage that has superiority over Miss Barrington. And in response, there's a denial. They say that these are the amounts that are due and owing. In response, there's a denial. They say Miss Barrington defaulted on the note and mortgage. In response, there's a denial. They also say these are the amounts that are due and owing, and in response, there's a denial. Those are the 4 elements. And if you don't have a valid mortgage, I mean, in its simplest form, you need a mortgage to have mortgage foreclosure. And
But
if
don't the rules, however, with respect to the amount owed, isn't payment specifically listed as an affirmative defense in the affirmative defense pleading?
if you're saying tender and payment in full, yes. However, also before you get there, they have to prove that there's a default. That's their prima facie burden
So
here.
counsel, it's your position that in some cases, the prima facie case and the affirmative defenses overlap.
Sometimes they can't.
Sometimes it's not just statute of limitations or duress. Sometimes elements overlap both. And here's a case where that happens.
Right here, this exact case is where they overlap. When you're gonna say that the mortgage is superior and we say, no, it's not. And this was something that was tried. It wasn't like it was like a one-off statement. This issue was tried in the plaintiff's case in chief. And what you have to do in Cooper is, the way I construe Cooper, is you don't need a separate cause of action for reformation or reestablishment, as long as you can clearly meet that rebuttable presumption. And in this particular case, there's not substantial competent evidence. The gentleman, Mr. Serge Alexis, was the trial witness. Now, he had the pretty difficult task of laying what's called the boarding process predicate, where you have to show that the prior servicer vetted it for accuracy. It was vetted for accuracy, and the only way it would come through is everything was accurate. But then he said, in preparing in the weeks before trial and preparing for it, was the first time he noticed that there was an issue. Now, those comment logs that he was relying on were never introduced into evidence. And also this affidavit of an error or erroneous recording of a release. First of all, that was never introduced into evidence. But then I believe it was Judge Nardala who made me start thinking, that's not going to be sufficient, even if it's recorded in the public records and they bring that affidavit, presuming they could get by my inadmissible hearsay with an hearsay objection. But if they bring that affidavit, that doesn't all of a sudden bring life into the mortgage. The mortgage was released. If you record a affidavit saying it was an error, that's recording it, putting the world on notice that it was an error. But not only was that not introduced in this case, but that's not going to breathe life back into the mortgage. You have to do something proactive to do so. And that's why it would have been prudent upon them to do a reformation count, reestablishment account, maybe even a count to rescind the release. That puts us on notice of what they're going to be doing. Instead, they had a count for foreclosure, and then they had a count for reformation. The count for reformation was only on a legal description, which my understanding was a total red herring. That's not the issue. I mean, maybe the trial attorney got the case and there was a title issue and they did reformation, but on the wrong issue. The problem is, though, under the Cooper case that we both cite to, it is a heavy burden and they have to negate that burden. And I would argue it's not per se an affirmative defense when you have these denials of the allegations that they have. Again, was there a default? Is there a mortgage that's superior to Miss Barrington's interest? Is there a default? They haven't even proven a default in the case.
Would you please address Biggs versus Smith for me? At least seems to suggest that we should review release as proof of payment, which would be an affirmative defense. And that wouldn't be part of a lender's case in chief.
Let me check out the Biggs case real quick. I think we even cited to it, if I'm not mistaken. Yeah, just like in Biggs. So in Biggs, first of all, you have to show that there is some kind of evidence of fraud, accident, or mistake.
Who's you?
The plaintiff would have to do that.
That's how you read Biggs?
I believe so, yeah. And in Biggs, there was a release of the release was a valid defense, just like ours. And if the lender can't overcome it, then the foreclosure fails as a matter of law. Maybe I'm overlooking the point that you're trying to make.
No, I was just asking if you could address
I mean-
the general aspect for me, because to me, it seems like it's a Supreme Court case that we would have to deal with. And the way that I'm at least reading it is to suggest perhaps in more sweeping tones than you would urge us to consider that payment is an affirmative defense and that release should be viewed through the lens of payment.
Well, so the way I read Biggs versus Smith, which is a 1938 Florida Supreme Court case, is that a recorded satisfaction equals prima facie evidence of extinguishment of a mortgage. And basically, when there's a recorded release, it's a valid defense. If the lender cannot overcome it, the foreclosure must fail as a matter of law.
But do we typically overcome affirmative defenses in plaintiff's case, Chief?
We don't, and that's why.
That's why I'm struggling with that case.
I understand that, but if you look at the allegations in the complaint, and if you look what they have to prove here, they have to prove a default. How do you prove a default when there's been a recorded satisfaction? And then basically, if you look at the loan history or the pay history in this case, the pay history shows a bunch of times that there was a payment shortly before the release, paying off the full $17,000 on the loan and some change. It's not exactly 17,000, 17,000 change. The lender in this particular case recognized that Miss Barrington was aggressively paying down the loan. And let's just take a step back. Who stops when there's $11,000 due on a note and mortgage? You don't. There was the satisfaction. Matter of fact, the lender said that payments were still coming in, but just to correct my opponent, those payments were from a different loan that Miss Barrington had with NationStar. That's why payments kept coming in, because they're now misapplying that other loan. But here, before the court, unlike Briggs, they had evidence of fraud, accident, or mistake. Here, there is no such evidence. That one snippet that he points out in the transaction history is not competent evidence. The witness testified, Mr. Serge Alexis, that his knowledge of the mistake came from the comment logs that he readily admitted were not furnished at trial, but even worse than that, were not even provided to defense counsel or in discovery at any point in time. That's what he was relying on to determine that there was a mistake. And at the trial court level, I objected. I cited to the Gonzalez case, the same one that we cite to in this brief. Gonzalez says that you do not have substantial competent evidence if you're relying on documents, business records that have not been introduced into trial. And Mr. Alexis did not point to the pay history that was introduced to refute anything regarding the release. What he pointed to were comment logs that were not even introduced at trial, let alone ever provided in discovery. He also pointed to the purported affidavit that the release was an error. However, that was never filed with the court. So there's not substantial competent evidence to rebut the heavy presumption in this instance that the release was done and that payment was made. And when we look at the pay history that they are relying on, and first of all, let's take a step back. If you look at the comment logs that they have that were introduced into evidence, one of the issues I had with them is that they're incomplete. They start off in 2019. But if you look at the pay history that was introduced into evidence that they're relying on, it says 3 times that that payment of 17,000 and some change was made and that it zeroed it out, the balance owed, to 0. The only evidence of payments coming in were from what Mr. Serge Alexis said was from a different loan. Nobody stops paying when there's $11,000 due on a loan. People stop paying when you get a release of mortgage. So unlike the Biggs case, our case here, there's no evidence of fraud, accident, or mistake. And in the absence of this evidence, it's an absolute bar to overcome the extinguished mortgage that is created by the presumption of the release. I could address the fees and costs, but before I leave this issue, do y'all have any other questions you'd like me to address? The fees and cost issue was not addressed by my opponent. I want to address it real quick. We cited the Ward versus Citibank case, which is a 6 DCA case from 2024. Had the pleasure of handling that trial court case and the appeal as well. And the 6 DCA found that you need evidence of the work performed by counsel so that the trial court has a basis of determining the reasonableness of fees. Here, they alleged in their complaint as a prima facie element that they are trying to recoup reasonable attorney's fees. The evidence that they introduced, the pay history and some of the other documents, the intent was to prove that they're entitled to reasonable attorney's fees. But in here, they did not introduce any evidence to support that in the form of invoices, timesheets, or any kind of other description that would allow the court to look at what kind of work was performed to determine if that was reasonable. Also, they did lose the case, so you're only entitled to fees if you're the prevailing party. But the court did the right thing in entering the involuntary dismissal on the fees issue. It was a prima facie element that was put forth in their complaint. It was a prima facie element that they tried proving at trial, and they fell short. And the court was also correct in granting that involuntary dismissal. They also granted the involuntary dismissal on the reformation count. There was no evidence of that. And
That was by agreement.
Well, no, because remember, they only came up with the agreement when I started my motion for involuntary dismissal. At that point, it would be dismissed involuntarily.
What I mean is, I don't believe the appellant's even challenging.
Oh, probably. I think they conceded that then. So going back to the issue on the mortgage foreclosure. So in Cooper, remember, if you can show by substantial competent evidence that clearly this was an issue, then you don't have to have a separate count. But here I want to read exactly what the court ruled. And it says, and this is a quotation: "The only evidence we have is that there was a release in this case that was filed by the prior lender, I guess, NationStar, and a suggestion that it was done in error. But we don't know what that means yet, if we ever will. There is just that. However, a release that's been recorded, in this case apparently, or at least a release that's been referenced in the evidence in this case." The judge's statement there in his ruling shows that they did not meet their burden of proving that, of overcoming the rebuttable presumption. It shows that the judge was confused about what the error was, and there was no substantial competent evidence to back it up.
Counsel, I'm sure you agree with the heavy burden language in Cooper, but do you agree with the idea that you don't have to bring a separate count to bring life back into the mortgage? I think
Actually,
Cooper got that right, or do you think this court should go a different way?
I think this court should go a different way for due process, first of all. Second of all, in this particular instance, if you look at their complaint, they're not putting us on notice of anything to do with.
It's a vanilla foreclosure count. Is that your point?
There's nothing to put us on notice that they're trying to cure the release of the mortgage that they did.
If they had put it in the wherefore clause, would that be enough?
I would certainly say yes, because the wherefore clause is enough to give you due process notice of what they're saying. But in their complaint, they never mentioned any kind of mistake, accident, anything. The first time we heard about this was at trial. And frankly, that's because even the witness admitted he wasn't aware of it until 2 weeks before trial. So that invites trial by ambush. In this case, fortunately, we were able to handle it. I think in the next case, it'll cause a slippery slope. And, and equity, let's talk about what's fair. It would be to put it on your script in your complaint so that the parties have due process notice of what you're trying to do. But the bottom line here is, according to my reading of Cooper, which I don't think this court should follow, still, they haven't met their burden of overcoming the heavy rebuttable presumption. And when you don't do that with substantial competent evidence, you need to have it as a separate count. That's how I read Cooper. Any questions on that? All right, I have 5 minutes left. If there's no more questions, I'll just sit down.
Thank you.
All right, thank you very much for the opportunity.
You. So George Nadal, thinking about your question. So counsel's question was, there's nothing bringing that mortgage back to life, so to speak, but that's not the right way of thinking. I think you're taking, offhanded comments and just saying a mortgage isn't died or resurrected. The mortgage is a lien on the property. And the question is, do you have notice of it as a subsequent purchaser, which was not an issue in this case. Ms. Barrington knew she signed a mortgage. yes, an erroneous release was recorded, and an affidavit that it was erroneous was also recorded. And the question was, well, do you have to plead a separate count? Do you have to first maybe file a declaratory judgment suit, then do your foreclosure next? Get that judicial order first. And the answer, of course, is no. We relied obviously on the case law at the time, which includes Cooper versus Walkowitz, that says you don't need to plead a separate count. So to say, well, now you should have, the court I know is not binding, but obviously we did what the law said we could do. And the evidence presented, viewed in the light most favorable to the plaintiff, showed that we established a prima facie case. Whether or not the defendant will present the release in an affirmative defense and whether or not we can overcome the presumption to overcome an affirmative defense was never reached because the court granted involuntary dismissal. Now, he said the trial judge was confused. I don't know if the confusion is the right word. I think the trial judge was more like understood what was going on. I don't think the trial judge wasn't smart enough to know what was going on. He's just like, well, I don't think your evidence is good enough. And I don't think you haven't played it as a separate count. Obviously, the separate count you don't need, but as for the evidence not being good enough, that goes to weighing of it.
But counsel, can I stop you there?
Sure.
I think I just heard you to say that the trial judge said you have to plead it as a separate count, which you disagree with. Did you disagree with him there when he said it?
The trial counsel, I don't know if they articulate it as well as I'm going to try and articulate it. But I think the idea being that they pushed it as saying, well, that's their affirmative defense and we haven't gotten to it yet. We'll deal with it on rebuttal, which we never got to. Whether or not we said to the judge, hey, this has to be played as a separate count at trial specifically. I don't know if my trial counsel said it, but we certainly said it in the motion for rehearing that we filed. And we cited Cooper versus Walkowitz to the trial judge. So we did argue this to the trial judge, because I think in this situation, that's the type of error that would kind of appear on the appear for the first time right then and there and say, no, we don't need to plead as a separate count. All we need to do to prove a prima facie case is to establish the 4 elements, which we did. Now, we said we didn't prove a default. Well, we have evidence that shows there's $11,000 still due. We have evidence that no payments been made since 2020. Whether or not the quality of that evidence, I think, is fine.
But you can record a release for reasons other than non-payment.
You could record a release because you just being a nice person that day. You could
Right.
do that.
So evidence of payment outstanding doesn't necessarily mean evidence that the recorded release was mistaken.
Well, I think the fact that they recorded a release, but I would say I have not known lenders to record releases just to be nice. They record it, and if you look at the facts of this case, a payment came in about $17,000, which Mr. Alexis said that was for a different loan. That's why they recorded the release. That payment was backed out because whoever made that payment should get credit for it. And they recorded that the release was in error. On this record, and I got 20 seconds left, on this record, involuntary dismissal was error. And I think that this court should reverse the involuntary dismissal and remand to go to trial on whether or not the release was in error. And I think we will meet the burden at trial, but that's for a different day and maybe a future appeal if we ever come back. But that we ask that the court reverse and remand to hold the trial on the release count, on the affirmative defense of release. Unless there's no further questions, that's
Thank you.
all right. Thank you. Thank you, everyone.
Thank you.
We'll be in recess.